So basically, as far as this trial advocacy is concerned, we shall be looking at case analysis and trial strategy. So if you can listen to this video after the very end, then you shall be able to understand examination in chief, case analysis, which means that exhibits cross-examination and impeachment, trial objections, opening statements, as well as final submissions. Please, if you have not subscribed, subscribe, like, share, and comment. But by the end of this video, then you shall be good to go as far as the final exam of trial advocacy is concerned. Remember that we did a moot out of 60, so this is going to be out of 40. So introduction: advocates must be storytellers because trials are contests where the best storyteller wins. However, advocates will not tell their stories in vacuums. Unlike other storytellers, the context of an advocate's story is determined by the legal regime that governs the remedy sought in a case. This can be defined in the detailed examination of the facts and evidence making up the case, and also the strengths. So basically, when we talk about case analysis, you have to look at the facts you have, you apply the law applicable, the issues, resolutions, and the remedies available in those facts according to the law. So basically, that's why it's very, very important to understand your facts very well, then apply the law, and you come up with a remedy. So in looking at that, of course, we shall have to see whether the plaintiff or whether the facts disclose the cause of action, and then after that, that's when you see the appropriate court. You see who is to sue and be sued, and then you can proceed and then bring up your plaint. But basically, that's what we mean when we talk about case analysis. You are looking at the facts you have, the law applicable, the issues, and the possible remedies to your client. So a lawyer's mind preparation involves considering and deciding which cause of action their claim would be founded. If they are in a criminal trial, they would have to determine the offenses disclosed by the facts. So theory: there are several ways to define a theory. Your theory of the case is your version of what really happened and why you should win. It must be logical, fit the legal requirements of the claim or defenses, but is always expressed in non-legal terms. So basically, you have been hearing about theory and what does it mean. So theory basically means that for you, what's the basis of your case. So if you interpret it as your lawyer, what is the theory of your case? Because if, for example, it could be a murder case, but for you are saying that it was in self-defense. So basically, that becomes your theory. So it basically means that all your theory of your case is going to be on self-defense. So your theory is the adoption of your story in the legal issues in the case. The theory of the case should be expressed in a single paragraph that combines an account of the facts and the law in such a way as to lead the trier of facts conclude that your client must win. So that combination of facts beyond dispute and law, which is in common sense and emotional way, leads to the jury or judge to conclude that a fellow is wrongfully accused or should not be severely punished. So one central theory that organizes all facts, reasons, arguments, and furnishes the basic position from which one determines every action in the trial. So basically, that's what we talk about when we talk about a theory. For you, if you look into the facts, what is the thrust? What's the thrust of your argument? We have a case theory. Everything you do at trial will be continued by your case theory. Your case theory controls your discovery and trial preparations, choice of court, what's used in your opening statement, the evidence you lead, what is asked on examination in chief and cross-examination, what's said in your submissions. To develop and express your theory, ask these 3 questions: what happened, why did it happen, why does that mean that my client should win. So basically, all your preparation is governed by the case theory, because like they have told you, if you basically accept that in a murder case that there was murder, but then it was caused by self-defense, then it basically means that's going to be the theory of the case. Then your question will examine the evidence you bring. All of them will be backed by the theory of your case. So if your answer is longer than one paragraph, your theory may be logical and true, but it's probably too complicated. So it must be logical. It speaks to the legal elements of your case. It is simple and it is easy to believe. So a theory of the case consists of the following parts: the relevant law, the facts of the crime, common sense, as well as a theme. So a detailed book of a theme So basically, when you're bring about your theory, you must make sure that this one it's backed by the relevant law, it's backed by the facts, common sense, as well as a sim. So from there, let us look at trial strategy. So from developing the case theory to making an opening statement, the objections made, the questions put to witnesses during the examination in chief, cross-examination and examination, the impassioned to the impassioned final submissions, and attacking the credibility of the adverse witness. So basically, when we talk about trial strategy, now your theory helps you to make your trial strategy. So it includes planning your legal arguments or submissions, planning the prosecution of your case, and also decide which witness to call and in what order. So you consider the following suggestions. Plan to start with a strong, important witnesses. Start with witnesses who can set the scene. In general, call witnesses in chronological order, e.g. plaintiff, call collaborating witnesses. Then if several witnesses are needed to lay a foundation, such as a chain of custody, call them seriatim. Call lay witnesses first and expert witnesses, and finish with the strong witnesses. So planning your cross-examination, anticipate in advance evidence that should be objected to and places where your opponent may object to your evidence. So basically, you have to understand that cross-examination is basically by the person who brought the witnesses. So when we talk about cross-examination, we are looking at questions as where, why, how, and what. Basically, the questions you ask in cross-examination. Then suit disposal strategy. After an advocate has planned their case theory and trial strategy, they must come up with a strategy informed by the above two aspects on how they shall dispose of their case. So example of civil litigation disposal plan, plaintiff and defense. For example, obtaining maximum compensation, adduce evidence challenging entire claim or counterclaim, or use both above to reduce liability, settling at earliest, separate claims or joint of parties, technical issues with claims of joint of parties and claims. Then prosecution, choice of charges, a complete denial or strategy, multiple charges, confession strategy, then an admit and explain strategy. So basically, those are the defenses which are available in criminal proceedings, as well as the defenses available in what? In civil litigation, as the way we can see from above. Then from there, we look at examination of witnesses. So you have to understand basically examination, like they were explained. Definition of examination in chief, the Evidence Act section 136. Examination in chief is the first examination after the witness has been sworn in or affirmed. So it's examination in chief is by the person who brought in the witnesses. So the major objective is to determine the admissibility of evidence, to prepare a witness to lead evidence in trial, present persuasive and credible evidence, and prove each and every element of the cause of action. So basically, examination in chief, if you bring a witness, those questions you are asking the witness, it's always examination in chief, and they always ask this in final trial exams. To assume you account for the plaintiff, please proceed and give us the question you would ask in examination in chief. So you have to understand that examination in chief, you ask open-ended question. What, where were you at this place? What did you do? How did you know that? Those questions of what, where, why, and how. Then also have from there what we call leading questions. During examination in chief, you have to ask. During examination in chief, the advocate is forbidden from asking their witnesses leading questions, especially on disputed aspects. So leading questions are always asked in cross-examination. So in here you ask open-ended questions. So you can ask your witnesses a variety of open and closed questions to obtain the information you require from the witnesses. So for example, when was the meeting held? Where was the meeting held? Why was the meeting called? Who was present at the meeting? What was discussed at the meeting? And how was the meeting conducted? So basically, those are what we call open-ended question. Then from there, we have to look at cross-examination. Cross-examination, you have to ask questions that basically are closed leading questions. So when we talk about cross-examination, you ask questions which require a yes, no, like that. You said on this day you were in the market, yes, and you found the other person, yes. So you give the person the answer, and then you want him or her to confirm. Whereas in re-examination, what you do in re-examination is that re-examination, you are just trying, you can ask any of the questions because you are trying to make sure that in case there were some loopholes that came out of the cross-examination, you're trying to amend them. Basically, that's how you do re-examination, by the person who brought the witness. Witness statements, civil proceedings differ from criminal proceedings in the form of witness evidence and the presence of its preparation. Evidence in criminal proceedings starts with recording statements. On the other hand, for civil litigation, the law has been amended to provide for witness statements. So basically, I think you have done witness statements. Those of us who have done moot, we now know what a witness statement is. It basically contains the evidence of that very witness, and it's governed by the civil procedure rules. It's governed by the civil procedure rules. So witness preparation, so you have to prepare witnesses but not coaching him, and that's when you come up with a witness statement. So let us look at documentary exhibits. An exhibit is a document, recorded or other tangible object formally introduced as evidence in the court by a party who wishes to rely on such evidence to prove their case. So basically, once your document is admitted, it now becomes exhibit. Types of exhibit, we have real or tangible evidence, demonstrative evidence, and documentary evidence. So documentary evidence generally refers to the virtual writings such as letters, contracts, memorandum reports, etc. Methods of introducing documents: trials. In criminal trials, usually documents are tendered through the testimony of witnesses. However, to avoid surprise and ambush, the prosecution provides their documents to the defense through the discovery process before trial. Then in civil litigations, documents can be tendered and admitted into evidence either by agreement between the parties at scheduling conference or not by counsel formally applying their admission into evidence. So basically, here we looked at how can documents be admitted in criminal proceedings. For example, we said that in criminal proceedings, if the parties agree, then they can also admit the documents before the trial. Then after that, we also looked at admitting documents in civil litigations through what we called scheduling conference. Then the one which has not been admitted, you can apply that it be admitted. Then that's why we had agreed documents, disagreed documents from the joint scheduling memorandum. So we also looked at joint scheduling memorandum and trial bundles, which are always prepared for purposes of moots. So main elements of foundation that affect the credibility of documentary evidence include originality, privilege, authenticity, relevance, hearsay, and evidential challenges with the document. So basically, when you're cross-examining or when you're tendering in the document, you have to ask questions as to originality, privilege, authenticity, relevance, hearsay, and evidential challenges. So foundations for specific documents: exhibits, pictures. A photograph is more relevant when it fairly and accurately depicts a relevant scene at a relevant time. Therefore, the focus in analyzing foundation for photographs evidence is whether the relevant view seen by the witness is fairly and accurately depicted in the photograph, and where there is no witness that can testify as where the pictures accurately shows what the witness saw, that the admissibility of the photos is placed in doubt. So basically, that means if you have photos and you are tendering in photos, you have to prove at the accuracy of the photographer in a way that he was able to depict what basically transpired on the scene of crime. Audio and video recordings. Audio recordings have for long been used and admitted in evidence and are the commonest in our Ugandan jurisdiction. In order to submit sound recordings in evidence in court, it must be established that the audio recording is authentic representation of the conversation it said to record. And how the case of Justice Mobiru in Twahwa, Sebi Orego versus Dringa Adnan held that the evidentiary value of a recording depends in large measure on who said what, but court's ability to use that information depends upon two qualities of their recording: audibility and intelligibility. So basically that's all we have on documentary evidence. On audio evidence, first and foremost, must be audible enough, and also it has not been tampered with or changed. So a video recording is in law regarded as a document, and it has been decided by courts that there is no difference in principle between a tape recording and a photograph. And also see the case of Twaha Sebi Olega versus Adnan. So it was held that the basic process for foundation of admission of recordings or on the position side to deny admission of audio evidence requires that the following be shown. 1, it must be shown that the mechanical transcription device was capable of taking testimony. It must be shown that the operator of the device was competent to operate that device. The authenticity and correctness of the recording must be established. It must be shown that changes, additions, or deletions have not been made, and the manner of preservation of the record must be shown. Speakers must be identified. So we also have the case of Okari versus Suruse Okero and another, where it was held that before authenticity or hearsay or whether a copy is accepted or the original is required. So basically, when you're tendering in this evidence of video, you have to ask this question: the reliability of the equipment used, what kind of equipment was used, the manner in which the basic data was initially entered, the measures taken to ensure they actually solve the data, the method of storing the data, the reliability of the computer program, what software was used, the competence of the person. This person must be competent to do so, and an independent third party should be able to examine the process and achieve the same result. So basically, this becomes the questions you ask when you are tendering in these documents. So emails and website, you can send Justice Madrama in International Limited versus Damaco Logistics. Expounds on the form and preservation. Emails must be accorded in order to be given full evidential weight as exhibits. The same applies to articles in the internet and social media evidence such as Facebook, Twitter, Instagram, and the post of the like plus WhatsApp messages. Points to note about tendering process. Most objections to documents being tendered arise from the lack of evidential foundations, and therefore the remedy may be to read the witness or call another witness to address the gaps. Documents that are identified are not part of the evidence, and counsel tendering them must endeavor to address the objection upheld and reapply for their admission as exhibits. Even where objections to documents are upheld or overruled, counsel must challenge such rulings. So it is possible to tender documents through an opposite party's witness. It is possible to tender documents through an opposite party's witness through cross-examination only then the aspects discussed above are fulfilled. So basically, that's how you have to tender in these documents. First and foremost, they are saying that objections always arise to the lack of evidential foundations, and therefore the remedy may be to lead the witness or call another witness to address the gaps. And documents that are identified are not part of the evidence, and counsel tendering them must endeavor to address the objections upheld and apply for their admission. Simple checklist for tendering exhibits: ask the witnesses that establish that he is competent. Then ask the witnesses to establish the existence of the exhibit. Ask the witnesses questions that establish sufficient foundation that the witness is able to identify the exhibit. Ask the witness questions that how they would be witness to be able to identify the exhibit, and the data the document was authored, who authored the document, who has custody of the document, who signed the document, features, letterheads, ID, and handwriting. So basically, those are the things you have to ask when you are tendering in the document. If necessary, establish an additional foundation to tender the exhibit, for example, originality, relevance, authentication, hearsay, analysis, and accuracy. So in your final exam, they might ask you to tender in a document. It could be an email, it could be a report. So basically, this is how you go about that to tender in a document. Cross-examination, I think you looked at that. We see that in a cross-examination, it's governed by the Evidence Act. You ask basically leading questions. So the lawyer must look and listen to determine if the evidence to challenge it has any of the following characteristics: contradicts prior testimony, conflicts with the testimony of other witnesses, conflicts with documentary evidence, nervous or uncertain response, addition or omissions of facts, be alert to the contradictions, inconsistencies, and also is the witness is vulnerable, and where is he vulnerable. So basically this is what you target on cross-examination. To prepare for examination, the lawyer should have thorough knowledge of one's own case, effective anticipation, familiarity, investigation of the case, among others. So basically this is how you do cross-examination. We said you basically ask for leading questions, and when we talk about leading questions, we mean those questions you have to put to the person, and then the person gives you the answer. And avoid using things like I put to you, I suggest to you, my client will say. Avoid using those things. Then cross-examination strategy, you must also have a strategy, friendly information, affirmative information, incontrovertible information, challenging information, and hostile information. So here basically you can ask questions that requires the person to say yes or no, like the way we talked about. You said on this date you were on the market, yes. And in the witness statement said on this date you are on the party. So there he will hesitant, but the answer is either yes or no. So that's go to trial objections, and we are looking at legality-driven attempt to prevent the admission of evidence or argument, sometimes on the basis that it's impugned evidence violates some aspects of the law. So basically when we talk about objections, that's what it basically mean. The purpose of objection to keep testimony fair and honest, controlling information getting onto the court record, to protect your witnesses, and ensure proper questioning. Examples of possible objections to the form of questions, leading questions, compound questions, or argumentative questions. So you can object to the tendering on of evidence. Remember, as after the person is trying to tender in a document, they ask you, counsel, do you have any objections? So at that very point, then you can stand up and say, I object, my lord, to the tendering of that document because it's not authentic. So one of the grounds where you can object to tendering in a document is authenticity, originality, and maybe it's not the person who authored the document. So those are some of the grounds that you can object to tendering in a document. Ethical and conduct issues. Ethical issues frequently arise in the context of making and meeting objections. Do not use it only as a tactic, device to interrupt on an opponent's examination. Act politely and severely at all times. When opposing counsel has an objection, stop your examination. Don't be rude. So let us look at opening statements. Opening statements introduce the court to parties' competing theories of the case. Opening statements generally are fairly short and focused on the key factors each party will present. So basically, I think you have heard about opening statements. For example, if the matter is about fraud and that's a cause of action, the plaintiff can stand up and say, my lord, a lot of people have lost land in this country, and land is one of the major factors of production. So as the judiciary, we must do anything possible in our means protect people from this fraud. That becomes the opening statement. So there is no clear, straightforward way of doing an opening statement, but it basically covers what you will be talking about and why you want to court to take it seriously. So basically that's what we call an opening statement. If you have done moot, I think we have tried to do opening statements. They are provided for by the Message Courts Act and also the Civil Procedure Rules. The purpose of an opening statement: courts in Uganda do not treat opening statements as mandatory, made due to time constraints and lack of an established practice for doing so. Yes, so opening statements are not mandatory, but the advantage is it helps the advocates to formulate and be in position to present a clear picture of the case. It helps the advocate to plan an approach that will arouse the interest of the court. It helps the advocate to plan an approach that will build rapport. For the defense, the opening statement presents the opportunity to keep the court reminded that there would be two sides to the case. So those are some of the advantages. The nature and content of the opening statement. Proper opening statements are not arguments. Opening statements are supposed to be limited to information the court of the facts that the advocate intends to prove. Then from there we looked at the prohibition against argument. It's not about the argument. The prohibition against exaggeration, don't exaggerate. Unlimited or no discussion of the law. Don't dwell too much into the law. Discussion of the facts. Opening statement is supposed to be limited summaries of the basic facts one intended to prove. Then exhibits, once the evidence is admitted, it becomes an exhibit. Structure of opening statements: introductory remarks present the central theme, a summary of the case told as a story, and then introduction of the actors, places, and instrumentalities. So basically, that's how you do an opening statement. Basically, opening statements, like they have said, they are not mandatory, but they always help you to connect emotionally with the court. Then the last thing we're looking at here is final submissions. And final submissions, I think we have all done them. They could be in criminal and civil litigations. We all do final submissions. And basically, final submissions, you are dealing with the what? With the element of the what? Of the case. So example of outline for structuring defense skeleton arguments in criminal trial. Start with convincing statement, lay out for the court what at issue in the case, lay out the defense case theory, argue the law, the standard of proof, presumption of innocence, and burden of proof, argue the facts, attacking the integrity of the investigation. Examples of outline for structuring defense skeleton arguments in a civil trial. Brief introduction, state the burden and standard of proof, tackle each issue, state the law, cite the written law, the analysis of the case. So basically, that's how we do submissions. We have done a lot of them, so I can't go back into a lot of details. So basically, this was a deep analysis of basically how you do trial advocacy. Remember, this subject was covered most importantly in moots, so that's what we should really be expecting, that trial advocacy was covered in moots. So if you have done mooting, then I don't expect you to have challenges as far as trial advocacy is concerned. But I would advise you to make sure that you go with your criminal proceedings notes, as well as the civil procedure rules, as well as the Evidence Act, because I can see most of these things are coming from that side. But once you have understood how do you moot in criminal and how do you moot in civil litigation, then trial advocacy is going to become very easy for us all. So I believe that we did mooting, and remember, mooting was out of 60%, and this is going to be out of 40%. So I know most of you have even passed the exam. You already got a 50 in moot, so you are just looking for additional marks. But please don't take it seriously. But I believe in you, and I know you can make it. Please, I wish you success in your trial advocacy exam. Discussion. We shall basically be going through trial advocacy and in preparation for the exam of the trial advocacy. So in case you listen this video up to the very end, then you will be we will do good as far as trial advocacy is concerned. So we shall look at case analysis, examination in chief, documentary exhibits, cross-examination and impeachment, trial objections, opening statements, and final submissions. So case analysis and trial advocacy. So basically, when we talk about case analysis, advocates must be storytellers because trials are contests where the best storyteller wins. However, advocates should not tell their stories in vacuum. Unlike other storytellers, the context of an advocate's story is determined by the legal regime that governs the remedy sought in a case. So basically, you have to understand that when you're analyzing your case, you look at the facts you have, you apply the law, the principle, and then you come up with a possible remedy. That's how basically we do a case analysis, by looking at the brief facts, the law applicable, the issues, and then looking at the possible remedies. So when we talk about case analysis, that's basically what we mean. So a lawyer's initial preparation involves considering and deciding which cause of action their claim will be found on